Good evening, everyone. Uh, Today's our resource person will join us in short time. Request you to please wait. Namaste, sir.
Namaste. Namaste.
Sir, we will start in 2 minutes.
Yes, yes,
Participants,
yes.
please
Yes,
switch.
yes. It's
Thank you,
okay.
sir.
Take your
Yes. Good evening, everyone. Welcome to the Human Rights Law lecture series organized by Department of Law, Central University of Karnataka. Today, for the session Human Rights, State Compliance and Social Transformation. With us, Dr. M.K. Matolli, sir. He's uh, uh, faculty from just- yeah, faculty Government Law College, Hassan. Among with us, Dr. Baswaraj Kubakadi, sir, Associate Professor, Head of the Department of Law, and Dr. Anand Chinchure, Assistant Professor, IQAC Coordinator, Department of Law, Central University of Karnataka are here. My request Mr. Prem Piyush Pandey, first year LLM student, to introduce the chief guest to all participants. Prem?
Yes,
Yeah.
sir. Hello, everyone. I am Prem Piyush Pandey, first year LLM student at Central University of Karnataka. I welcome everyone on behalf of Central University of Karnataka from Vaswaraj sir, Anand sir, Krishna sir, and Ragni ma'am. So let me start by saying that today's session is one of such topics which a person from legal background has to be very well versed with. And therefore, there is definitely a need to be addressed by someone who has his expertise in such area. So we have here with us Mr. M.K. Matolli sir to basically throw some light on the today's topic. So before we proceed any further, allow me to speak the glorious journey of our honorable guest. Let me tell you that when I visited Sir profile, I was very confused, shocked that what to add and what to take away in the introduction part and what to leave because all I see was achievements and achievements and achievements. So I decided not to leave a single line. So let me start the introduction of Dr. M.K. Matolli sir. Dr. M.K. Matolli, before joining Government Law College Hassan in September 2009, he has served as law teacher from 1995 to 2009 in Vasaveshwara Law College, Bagalkot. He was the principal of Government Law College Hassan for 7 years. He worked as a coordinator of Human Resource Development Institute of BVV Sangha in Bagalkot for 5 years and empaneled as resource person at District Training Institute, Hassan, Karnataka. He worked as master trainer at Judicial Training Program organized by Karnataka Judicial Academy, Bangalore, and KHPT on the rights of marginalized women. He also conducted training session for gazetted probationers and Class 1 and Class 2 officials on government litigation, conducting rules and constitutional dimension of RTI Act at RTI Act Administrative Training Institute, Mysore. He served as Special Officer Law at the Department of Collegiate Education. Just a minute. Collegiate Education Bangalore and coordinated with the government pleaders in conducting litigations on behalf of Government of Karnataka. He has a vast experience of delivering more than 80 special lectures for state government employees on POSCO in 2017. He has published 26 papers in legal periodicals and law journals, especially in the areas of IPRs and human rights. His area of interest include intellectual property law, corporate law, law of evidence, international trade law, and personal law. So all I can say is it is an honor for us and privilege for our viewers to have you on board with us, sir. I would be highly obliged if you could take up from now, sir. Over to you, sir.
Thank you very much to the esteemed faculty of the Department of Law, Central University. In fact, there are my friends, Dr. Anand Chinchure, and my student friend, Dr. Kubkaddi. And we have the other esteemed colleagues there. And in fact, I'm very happy to be amongst you with my colleagues. To start with the present or today's topic, when it was asked to me about the topic, somehow I have been there in the on the last day rather. It is better also in a way because what I feel is here we need to have some introspection about the interplay of human rights in the day-to-day life as as we are the people belonging to this law segment or this legal system. What sort of interplay is there between law and society? And in terms of the human rights, when I say law, it is human rights. So what is the interplay between human rights and the society? that is to be unearthed. And in the process, while we link both of them, there is a role for the state, and that I have picked up as the state compliance. So to be precise, my today's delivery is about what the human rights are in a peripheral sense, because much has been said about these human rights for the last 5 days. And at this stage, I'll be telling you about the concept of human rights as we can understand them for the purpose of linking them with the social transformation. That is one aspect of it. The other aspect of it is what is social transformation and what exactly the society has contributed to the change in law, and what the changes in law have, in how the changes in law have influenced the society or the social transformation, and what has been the role of state in the interlinkage between the human rights and the society is my today's delivery topic. And I think I'll be delivering it for about 40 to 45 minutes. Then I'm quite open for the questions to the participants. Okay. Let me begin with the statement that law is a social device. I'm telling it because I know that I very much, I'm very much aware that there are people who are from the other disciplines also here. But for other disciplines also, law is quite relevant. So for that reason, I say that the law is a social device. It's a social device because there are in society very many social institutions. One such institution is the legal system also, the law also. Law enforcing mechanism is part of society. So in that way, it is a social device. Now, state is born and is living for the noble purposes. Here I take you to the origin of state, because when in the ancient time, there was no state as such. So the human beings were unorganized. There was anarchy, there was chaos. But slowly, people started associating themselves and they formed a group. And that group, after several centuries, it became a religion. And that religion was regulating the human behavior, group members' behavior. But it was not possible for the religious groups to regulate the human conduct in formal sense. So like that, there was the emergence of the institution called as the religion. And in Western countries, these religions were the Christianity, and the churches emerged. So the church started controlling the human behavior, but the churches also felt that it is proper to have another specialized body. And slowly, there became across the state. And this notion of state is backed up by the social contract theory. As we always read in political science, sociology, or even in law, Hobbes, Locke, Rousseau, these theories, if we study, we come to know that people together, they formed an opinion to form an association called as the state. In India also, by the time when we got independence, by the time when we started forming the Indian Constitution, there was a sort of social contract. By virtue of that social contract, we are in the domain of Constitution now. So in that way, state has emerged. Now, I said, state is living for noble purposes. State's purpose is not to regulate the people, not to punish the people, not to tax the people. State is not an evil at all, necessarily. For Karl Marx, it may be. But what I say is, as the state was propounded, it was propounded for the purpose of serving the noble cause of welfare of people, good being of the people. And it was there to see that the people enjoy peace and order. So in that way, the state got emerged to start with. And this concept of state, later, it is being intermixed by this theory of law. because we equate here the state with law. What is law? Law, there are basically two theories, in fact, three theories, but for our purpose of understanding the human rights, I say that there were totally basically two theories of the state, of the law. The positive law theory and the natural law theory. Under positive law theory, a sovereign gives commands, and these commands or orders are obeyed by the subjects, because if they don't obey, there are punishments. This is called as positivist law theory. Here, law is as it is given by the sovereign, we have to obey it, irrespective of the fact whether it is good or bad, irrespective of the fact whether it is moral or immoral. So that is the positive law theory. The other version of the law is natural law theory. Here, law is nothing but the group or set of objective moral principles. And from where these objective moral principles come? These objective moral principles come from the human nature, human reasoning. Then how the man develops reasoning? Our reasoning is based upon the laws of nature. One should not steal, one shall not kill. I should not kill other person. This reasoning I have because this is the law of nature, that I should live, others to live. So in that way, the human behavior is governed by the rules of nature. And the human behavior, when it is being practiced and propagated at large, it becomes the morality. And that morality, it takes the objective shape, and that becomes the law. This is called as the natural law theory. Now, these human rights, where can we fit them? Can we fit them in the positivist law theory or naturalist theory? Definitely, it is under the natural law theory, because under natural law, we have natural rights, we have morality, we have individual freedoms, individual rights. So, as the name itself suggests, human rights are the rights available to the people for the reason that they are humans. I have human rights because I am a human. They are basic, indeterminate. So we always say about three characteristics of human rights. They are indefinite. Doesn't mean that they exist for these many terms or these many days. They are indefinite. They are universal. They are universal means everywhere, whether it is democratic country or a totalitarian country or a capitalistic country, whatever. These rights are available in every part of the world. That is second. Third thing is they are indivisible. It means you cannot forego them. Because of the fact that we are human beings, we are bound to enjoy the human rights. We can't sacrifice our human rights. There is no right to sacrifice the human rights. So in that way, human rights are basic. This is how the human rights are part of naturalist theory. Doesn't mean that the positivist theory do not accommodate the human rights. If we observe the present day governments in England and India and also in America, we see that there are very many provisions which categorize us as the positivist government. For example, in England, Parliament is supreme. India, Constitution is supreme, but under the Constitution, we have the government to make the laws. And in America, President is supreme. In that way, what happens is, there is supremacy of someone, and they give us the law. And if we don't obey the law, there are punishments, there are processes. In that way, there is positivism. But this positivism or this sovereign is not limitless. There are limitations upon him. There are restrictions upon him. There are legitimate regulations upon him. That's how in India, there is judicial review concept. All the laws passed by the governments, whether central or state, must be in consonance with the Constitution. Otherwise, they are void. What does it show? It shows that the sovereign is not limitless. So also in England, we say that Parliament is supreme, but there are conventions. In America also, there are checks and balances in the system to regulate this sovereign. In that way, there is positivism and also there is mixture of the naturalism. So, in modern day state, human rights are the clear-cut reflection of the idea that the governments are not limitless and they are bound by the human rights law or the human rights jurisprudence. So this is how the human rights play an important role in the business of the state. Okay, whatever may be the kind of the state. This is the concept of human rights as to how we have realized them in the civilized states notion. Okay, now, having said about it, let me tell it to second segment. This is just an introductory part as to how I am approaching it. Now, the thing, what I want to share with the participants here is, what exactly are the human rights? At least from the point of view of we, the students of law in India, or from the students of any other discipline in India, what are the human rights? Let us try to understand what are the human rights. The human rights, if I can go to the definition of human rights, just a minute. If I can go to the definition of human rights as provided under Section 2D of the Human Rights Protection Act. Human rights means the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. See the definition of human rights. This might have already been told to you by other speakers already. But I want to highlight here one point, that human rights means the sum total of rights guaranteed under the Constitution plus other rights embodied under the international agreements or international instruments. It means human rights is a broad concept than the fundamental rights. Fundamental rights are guaranteed under Part 3 of the Constitution. See, for example, dignity, equality, liberty, all those are there in Part 3 of the Constitution. Apart from that, if there are any new additions to these rights under any international covenant or agreement or any instrument, that will also become a human right in India, and that can be enforced before the courts in India. This is how the human rights are being defined under the Indian law. Okay, now this is the definition of human rights. Now the question is, I want to resolve certain 2-3 issues at the beginning itself for the students here. One is, what are the types of these human rights for the purpose of today's deliberations? I say the human rights can be classified into 2 categories. One is human rights in the negative sense, human rights in the positive sense. Negative sense, it means the state shall not take away the human rights. See, when we observe Part 3 of the Constitution, because entire Part 3 of the Constitution is human rights only. The very first article in Part 3 of the Constitution is Article 12. The idea behind inserting Article 12 to define the state at the beginning itself is to say that the fundamental rights are guaranteed against the state. Hence, state is first defined under Article 12. So the thing is, the fundamental rights are guaranteed against the state. Then, in what way the state shall not affect the equality, the state shall not act unequally, the state shall not discriminate, the state shall not take away freedoms, the state shall not take away the right to life. Negative sense. Human rights or the fundamental rights in the negative sense. So this is how rights are understood, or human rights are understood in this way. For example, custodial deaths. When a custodial death takes place, human rights in the negative sense is violated. Then when, for example, encounter deaths, when these human rights are violated in this negative sense, there can be complaints to the Human Rights Commission or State Human Rights Commission or Human Rights Courts, whatever. Then the Human Rights Courts or the commissions will see, they will recommend for payment of compensation. And they will be recommending for various other remedies. So this is called as the compliance of human rights in the negative sense. when there is infringement of human rights, the state agencies must comply, or the state must comply with the fundamental rights in terms of payment of compensation. That mechanism is there under the Human Rights Protection Act. And the NHRC has passed so many orders. And especially during COVID, every day an order used to be passed, asking the state or central governments to pay compensation or to facilitate this and that. And that way, this is called as whenever there is infringement or violation of the human right, the state comes into the play. Okay, this is one sense. Another sense in which the human right is understood is the positive sense. It means not that the state should just sit silently and it should not infringe the rights. It should assist the people in enjoying their human rights in a more meaningful way. It should not be a spectator. It should facilitate them a good life by way of facilitation of the enjoyment of human rights. This we can see by virtue of the expansion of the inclusions under Article 21 of the Indian Constitution. What Article 21 says basically is, no person shall be deprived of his life, right to life and personal liberty, except in accordance with the procedure established by law. See, that meaning of life has been given an expanded meaning. For example, right to live means right to live with free and compulsory education till the age of 14. Right to live with clean drinking water. Right to live with the livelihood. All these are inserted into the Part 3 of the Constitution, that is Article 21. Whatever is there under Part 4 of the Constitution has been inserted in Article 21 to see that the Supreme Court is facilitating the enjoyment of human rights or the fundamental rights. So, in that way, there is state compliance of the human rights in this two ways. One is ordering compensation and taking actions against the concerned public servants for the violation of human rights. The other one is facilitation of human rights by way of enforcing fundamental rights under Article 21. This is state compliance. So, friends, I told you about the human rights idea of human rights and the state compliance, what the state compliance is. Now, I'll take you to the other concept in my lecture, that is social transformation. Then I will try to establish a linkage between law and social transformation, or human rights and social transformation. Then we can see to the other things in the deliberations. Okay. Now, the social transformation. Before I address this question as to what is social transformation, I should first answer a question as to what is social change. First of all, we know what is society. Society is the web of social relationships. There are sets of social relations between the people in the community. And these social relations in the form of web that constitutes a society. Okay. Now, what is social change? When the interrelationships between the human beings in terms of the interpersonal relationships takes place, there is social change. For example, what was the kind of relationship between husband and wife some 50 years back? And what is the kind of relationship between husband and wife today? There is definitely a change. 10 years back, what are the relationship between kids and the parents? And what is the relation between kids and their parents now? Lot of change. Schools, how are the sense of change? Man is basically a changing creature. He don't want to be like what he was yesterday. That is his basic nature. Otherwise, he is not a human being at all. That is why there is a social change. social change is natural phenomenon. And because of this social change, the society is always dynamic. I told you as to what is this social change. The social change consists of changes in economic affairs, changes in social policies, economic policies, political ideologies. Now, what was the political ideology some 50 years back is no more the political ideology now. Majoritarianism has come. Some 10 years, some 15 years back, that was not the concept. So political ideologies are changing. So these are leading to the social change. When social change takes at the larger size, means consistently on widespread basis, that is called as social transformation. Society itself gets transformed. There are certain short-lived changes. For example, during COVID, there were some social changes. There were some changes in interpersonal relationships. But after COVID, everything has gone back to the originality, and now we are remaining the same as family or at school or something else. That is a temporary change. But on the substance, I said about the husband-wife relationship, parent-children relationship. Over the decades, the social change has been so phenomenal that now the total social transformation has taken place in familial relationships. So this is called as the social transformation. Now, when social transformation takes place, there is a change in social structure. Social structure itself gets changed, and that occurs at a massive level. And what has happened in terms of social transformation? Just to give you an example as to how we have witnessed the social change or social transformation after the commencement of the Indian Constitution is we had inequalities, accepted inequalities in the system. So there was Varna system, there was caste system, there was exploitation. All these were described as genuine. All these were described as legitimate some 50 years back. Now, what has happened over the last 50 years or so? Things have changed. Society changed. Why? Might be the social approach have changed. Political ideologies have changed. The law has taken care of the protection of change ideologies. And importantly, they are taking care of the social transformation in desired direction. In other words, I should say, what Ambedkar thought in form of constitutional provisions of social justice is this society must change in the desired direction. And the government of India must be strategical to bring about this social transformation. This was the ideology of Dr. Ambedkar. And now, after some 70 years or so, we are able to see those fruits. Now the society is transformed. Still, there is a lot to be done, but society is considerably transformed. This is how there is a social transformation over the decades in our country. Okay. Another thing is that changes do not occur automatically. Sometimes changes occur due to the change in law. Sometimes the changes occur due to the change in politics, political ideology, changes in the economic reforms. For example, after the advent of WTO, LPG, liberalization, globalization, privatization, societies are changed. Now, the present government is having a type of ideology, and the previous government had another type of ideology. Because of all these influences, the society gets changed. The society on its own may not change that rapidly to become a social transformation. So social transformation is the result of organized efforts on the part of state actors like the law or the legal system and the society, including the polity. So this is the social transformation, concept of social transformation. Now, having said about the social transformation, before I go to that linkage, what is the social transformation? Because I share social transformation cannot happen on its own. It's a result of change in other sectors, other ideologies. What are the things that can influence this social transformation? Certain changes, some 5 factors I want to delineate here, which have been responsible for social transformation in India. And where can we fit in human rights in that? Where can we find the role of human rights in social transformation? That we will try to ascertain so that the present topic can be discussed. In fact, at this level. The first factor which has led to the social transformation is changes in technology. Yes, certainly. We are seeing that there is technological revolution, IT revolution. Now we are able to have faster communications. We are able to interact very quickly. That has got the merits and demerits. Both are there. And because of this, society has got changed now. What used to happen earlier? We were being influenced by our neighbors. We were being influenced by our own villagers. Because we are not moving out of the village for a long time. Okay, this is how it was quite possible at that time that the cultural dynamism was not that fast because the stagnancy was there, immobility was there, and the people had less mobility rather. But nowadays, what has happened is technology has changed us to such an extent that within few seconds we can interact with the person in the other part of the world. We can look to the attire which he is wearing very quickly, and I can be influenced. So I can dress like my friend who is staying in Japan very quickly. Within 2 minutes, I can do that. So in that way, see, there is a social transformation. So technology has played a pivotal role in transforming the society, and there lies the role of law. And this technology has changed the society, and in the way human rights are violated, and at the same time, human rights are also protected by virtue of the contribution by technology. So both are there, both the effects are there. Might be human rights are more concretized, more strengthened because of technology, or because of technology, human rights are at threat because of social media and because of access, because of digital technology. Now we are having threat to our privacy. I don't know how many photos of mine are viral in the social media. The moment I finish of this class or this lecture, that's possible. No, this is all in a way a threat to the person's privacy. In that way, so there is a social transformation anyway, and giving rise to the legal challenges. Number 2, another factor which has caused the social transformation is demography and ideology. Demography means the population, the type of population, the size of population, density of population, nature of population, types of people. So, how society changes in Pakistan is different from how society changes in India because the demographic factors are different. Ideology. Ideologies in England are different compared to the ideologies in India. Ideologies in America are different from the ideologies in countries like in India. Just to give you an example as to how the ideology can transform society. During COVID, we had lockdowns. Government used to say time and again that don't come out of the house. Even the governments have gone to the extent of saying that we will deliver you the food and water at your doorstep, don't come out. So we kept inside the house. But in America, after tolerating it for some months, they came to the streets, stating that we prefer freedom more than the lives. So confining ourselves within the house is threat to our freedoms, liberties. We love more the liberty than the life. This is their ideology. And these kinds of people we couldn't find in India because their ideology is different and our ideology is different. We say that ultimately human life is precious. We have to care for our own life and also for the lives of others. That's our ideology. So in that way, the ideologies can transform the society in a particular direction. That's another factor. Third factor which can transform the society is political life and the economic policies. Political life. What is politics in a totalitarian country? What is politics in a country like India where democracy prevails? We have faster and healthy transformation in countries like India. But in countries like Pakistan or China, where relatively totalitarian governments exist, the social transformation is definitely there, but it is not definitely on daily lives. It may not be. In that way, social transformation is defined and characterized by the type of political life we enjoy and the type of ideologies we cherish. That is the third factor. The fourth factor which has led to the social transformation over the centuries across the world is the legal principles and the legal institutions, the legal system. Law can also influence social transformation. And social transformation can also influence the law. That is how in law, we carry out the impact analysis. Impact analysis means law can influence the society and the society can influence the law. Interlinkages there. So impact analysis. So another factor is the society can also be transformed by the law. Just to give you an example as to how society has been changed now. Today we have living relationships. Today we have single parents. A person can have children without being married. And two persons may be belonging to the same sex also. They can live together. They can share everything. And it can be termed as the living relationship. It was not possible earlier. Because a legal protection is given to these kinds of relationships. And because of this, society is accepting them. So society has been transformed in line with the laws and the legal institutions and the decisions of the courts. So this is how the legal principles have also facilitated the social transformation. Then lastly, it's very crucial. Mass movements have transformed the societies. Mass movements means the public opinion. Public opinion is a very strong instrument which can change the society. It can bring about massive change in the society and the attitude of the society. In India, we can see certain movements. And if we take the independence movements, there were massive movements which changed the society from the somewhat anarchic society into the patriarchal society, one nation society. In fact, every nation is the result of transformation of the society into a patriotic society. So in that way, the mass movements can also lead to the social transformation. But as I said, one thing what I want to say here is, sometimes we definitely need social transformation. We desire social transformation. When we desire this social transformation, we make use of the instrument of law. Law is the most dependable and an effective instrument of bringing about the desired social transformation. That I can exemplify with some examples as to how law can change, or law can change the social attitude towards certain developments. So that is the law and its interplay there. Now, what are the intersections or interplays between the law and the social transformation. Here, I want to bring in some 4 situations about the interplay between human rights and the social transformation in the form of law. What has happened over the decades or centuries is transformation of society can take place independent of law. Without any change in the law, sometimes society gets changed. For example, when famines take place, earthquakes take place, COVID took place. When these national disasters take place, society gets changed. Now you see, despite the fact that the COVID has gone, still we have got, or we are living in a changed society after the COVID-19. We are not having the same society as it was there in the pre-COVID era. So in that way, there can be change in the society irrespective of the law. This is one segment. Then another thing is, contrary to law, society can change contrary to law. It means society can change in defiance to law. Society can change in defiance to human rights. This is where we are finding changes in law. See, for example, we have dowry system. We have the violence against women. We even now have untouchabilities. All these are what? These are the societal practices which are against the law, against the human rights. So this is another interplay between the law and the society, or the society and the human rights. Then another thing is, sometimes law facilitates the social change. Law facilitates the social change. It means law defines that something is good, something should be tolerated, and the society must accept it, and the society slowly accepts it. For example, live-in relationships. Law has stated that if one man and one woman stays together as husband and wife without any marriage, law cannot prevent that. Law has got no say in that. So this is what is called as the society is being transformed because of the facilitation by the law and the legal institutions. And the last interplay there is law causes social change. Law causes social change means law is instrumental in bringing change in the society. Now that is happening. I will take you to certain decisions as far as that is concerned to tell as to how this law has changed the society. Because there itself we have got the direct interplay between human rights and the society, and the role of law therein. I'll take that in these following or in the statements to come now. Okay, how the law has been instrumental. I'll take certain areas of the society now, then I'll try to discuss as to how the law has changed the society or the human rights. Because law, when I say law, human rights are implicit in that law, because nowadays the human rights jurisprudence is part of legal system, and we cannot segregate law from the human rights and vice versa. Because of that reason, I say that the law facilitates the human rights. How that has facilitated? First example which I want to take up is this human rights dimensions of the family. Family, a societal concept. If we take family, during the last 5 days, one or the other resource person must have referred to Article 16 of the Universal Declaration of Human Rights 1948. Article 16 Clause 3 and Article 16 Clause 1, they say that family is a natural and fundamental group of society which is necessary for the man. And every man and woman of full age and competence is having the right to marry. What it shows is human right. It is a human right to have family. The very fact that there is family and there are laws to facilitate the family life is nothing but saying that human right extends to the fact that we have family. So that is family. Okay, this is as to this family. Now, in family law or in family, we come across these relations. There is marriage, there are parents, there are children, parentage, guardianship, etc. For marriage, there will be free and full consent. Irrespective of the religion, whether it's Muslim law or Hindu law or whatever, all the laws say that for a marriage, the parties must have given full and free consent. This is part of human right. That's how I say that law has facilitated the societal change. Earlier, child marriages used to take place. Now, I don't say that they are not taking place now, but they are illegal. But the number is phenomenally reduced. So child marriages are not common nowadays because the law has been instrumental. So family is changed because of the human rights, the practicing of human rights. As far as this is as to how this family and family life is there. Now, another thing is, just to give you another, this many might have come across this Geeta Hariharan case. In that case, Supreme Court of India has referred to this CEDAW. CEDAW means this comprehensive agreement on elimination of discrimination against women. There, our personal laws say that the custody of the child belongs to the mother up to certain age, and after the child is grown up, after that, the natural guardian of the child is father and not the mother. All our families all say like that. But this Geeta Hariharan challenged these provisions before the Supreme Court, and she said, just because I am a woman, why should I be deprived of the guardianship or the parentage of my child when my husband is not living with me? Such laws are defective. And accordingly, this was agreed upon, and Supreme Court referred to CEDAW and said, even the woman has got the guardianship rights of the child. So this is how that is the family life is being influenced by the law. Then, apart from this family or the family life, now I want to take the participants to another example wherein the law has played a very important role in the area of maintenance. For the purpose of clarity, let me tell certain things to the participants here, because my law friends here know these things, but those who are not from law background may not be knowing about certain issues in detail. So I want to make it clear here that we have personal laws in India. It means we are secular. Secularism for us means we are allowed to practice the religion of our choice. In our personal matters, we are regulated or governed by the personal laws. For example, in terms of my marriage, adoption, inheritance, I am governed by Hindu law. A Muslim, in terms of his marriage, succession, wills, he is governed by Muslim law. So there are personal laws. This is so because Article 13 says, pre-constitutional customary laws, that is religious laws, will continue to be the laws provided they don't offend Part 3 of the Constitution. Our religious laws, if they do not offend Part 3 of the Constitution, they will continue to be our laws in our personal matters. That is how in Saira Banu, triple talaq was held unconstitutional. There is a nexus now, okay, between Part 3 and the human rights here in this way. Okay, this is the first thing which I said about this maintenance I was telling about. Maintenance, how the human rights have changed the society in this country. Under Muslim law, marriage is said to be a contract. And husband is free to divorce his wife by giving talaq, even now. Talaq. And when divorce takes place, first consequence of it is that the husband is bound to maintain his wife. Under the section 125 CRPC, when the wife includes divorced wife, when the wife is destitute and when she is not able to look after herself, she can claim maintenance from her husband, even after the divorce. And how long? As long as her destitute situation continues, she can claim maintenance from the husband. But their personal law, Quran says, a divorced wife is entitled for maintenance only up to the period of iddah, after the divorce. So she can claim maintenance only for the period of iddah. That is the law in Muslim law. But section 125 CRPC, a secular law, CRPC, because you know, criminal procedure code is a procedure to enforce Indian penal code, and Indian penal code is a secular law applicable to all religions. So also CRPC is also applicable to all religions. Now, Shah Banu Begum in the year 1984, Shah Banu Begum, she got maintenance under section 125. This was challenged. The matter went up to the Supreme Court, and the Supreme Court said that Shah Banu is a Muslim. She, as per Muslim law, she is entitled for maintenance only up to the period of iddat. Only up to the period of iddat under Muslim law. But section 125 CRPC is secular provision. A wife after the divorce must not remain as a destitute. She should be able to look after herself. Otherwise, it is a violation of her human right. So it is very essential that her husband maintains her, even beyond the period of iddah. So accordingly, the Muslim law was not applied and CRPC 125 was applied. And there was a lot of agitation all through the country in this regard, because the Muslims wanted not to give maintenance beyond the period of iddah. That was the view all through the country. And accordingly, at that government in 1986, a law was passed by the central government as a political agenda. That is the Muslim Women Protection of Rights and Divorce Act 1986. Section 3 was so carved out in that husband should make provisions for maintenance of wife during the period of iddah. It means he should pay her maintenance during the period of iddah. And under section 4, you can go for section 125 maintenance if both the parties agree, both husband and wife agree. How can the husband agree to give maintenance beyond 20? That's iddah period to her. So he will never agree and she can't go under section 125 at all. So in that way, her rights were virtually defeated by a piece of legislation in India. And the matter was not left over there. Then this matter was taken over by the Supreme Court in a subsequent case in Daniel Latif. In Daniel Latif, Supreme Court, Justice Rajendra Babu, to be precise, he said very categorically in that case that if we don't pay her maintenance, which is sufficient for her to maintain herself beyond the period of iddah, that is violation of her human rights. System fails in terms of violating her human rights if we don't enable her to get maintenance beyond the period of iddah. So the Supreme Court interpreted section 3 in such a way that he should pay maintenance to her so as to be sufficient to pay for future also, beyond the period of iddah also. But the time of payment must be during the period of iddah. He should pay it right now, within 3 months. But the amount which is fixed in the form of lump sum should be sufficient enough to look after her future needs also. That kind of revolutionary interpretation or purposive interpretation was given by the Supreme Court. Here, time and again, the Supreme Court referred to the concept of human rights. So what I mean to say here is, human rights have changed the society. Human rights have changed the social relations between husband and wife. So this is another example as to how this the society has been changed by that the Supreme Court decision. Then, to take you to the triple talaq case again, of course, triple talaq case is known to everyone, but there is another case wherein the human rights have emerged as victorious. Human rights of women have emerged as victorious, we should say. What has happened of course, there are criticisms against the judgment. Personal views are different, but here, what happened in a triple talaq case, Saira Banu case? All of you know that a Muslim husband, when he can pronounce it talaq ul biddat, talaq, talaq, talaq. If he does like this, there is an instant talaq. The very next moment, she is not his wife, he is not her husband. Then, is this kind of right available to the woman? No, absolutely no. Then, will it not? Are we not making her a destitute immediately after 1 minute? Yes. Is it violation of rule of law? Yes. Is it violation of equality or not? Yes. Because the same thing cannot happen with Christian women and Hindu women, but it's happening only with Muslim women. It is clearly the violation of human rights. That way, the petition went to Supreme Court, and you know all that this 7-judge bench was constituted, and a judgment came. Judgment came stating that talaq ul bidda is unconstitutional. There are two messages in this. Talaq ul biddat or triple talaq is unconstitutional. This was the decision in triple talaq Saira Banu case. Then what are the premises of this judgment? Prior to this, there was a judgment by one of the high courts, Narasu Appu. The case is Narasu Appu, a very famous case. In Narasu Appu, this triple talaq was challenged before the court. And the court said, Prophet Muhammad categorized triple talaq as the disapproved form of talaq. It is not approved by the Prophet Muhammad himself. Hence, it is not part of Muslim law. When it is not part of Muslim law, it is not law under Article 13, Clause 2. When it is not law, there is no question of verifying it for the constitutionality. Accordingly, it was left as it is. So it was untouched in Narasu Appu. But when we come to Saira Banu, 1617, court said, Prophet might have described it as unapproved or disapproved, but it is there in practice. Howsoever marginal or minimum it is there in practice. When it is there in practice by virtue of a religion, it should be held as unconstitutional. Of course, there are problems with the judgment in triple talaq because all the judges concur with the final conclusion that triple talaq is invalid. But all the 7 reasons are different. In law, we determine ratio decidendi on the basis of facts, reason, and the final conclusion. But in this case, facts are same. All the 7 reasons are different. Conclusion is same. A true jurisprudent cannot determine any ratio decidendi in triple talaq case. That's my personal view. Okay, this is what's called as this triple talaq case. And once again, I want to say here that the human rights have emerged as champions or triumphant in the Saira Banu case. So this is how family life has seen that the human rights have influenced the society. Okay, this is about this maintenance. Now another area, just 2 more areas I want to touch upon before I could go to the question answer session. I'll quickly wind up, of course. I'll not take much of your time. I want to take another case here to touch upon as to how the human rights have interacted with the society. That is Joseph Shine versus Union of India, 2018, SC 1676. Joseph Shine. In this case, the IPC section 497 was challenged before the Supreme Court. An NRI from Kerala, residing in UK or somewhere, he challenged this section 497 before the Supreme Court as violative of Article 14, 15, 21 of the Indian Constitution. How? what section 497 says is, you all must be knowing, adultery. Adultery means there is husband, there is wife. Third party comes in, he indulges in illicit relationship with the wife. And this is an offense against the husband, and the culprit or the accused is the third party. Wife is nothing. At best, she can be a witness, that's all. This is what the law existed until this Joseph sign. What section 497 says is, this is a very, very small section. Man, in the absence, if any man indulges in sexual intercourse with the wife of another man without his consent or connivance, it is not rape but adultery. This is what section says. It means when a person indulges in sexual intercourse with another person's wife without
Sir, excuse me, sir. Your voice is not audible. Yes, sir.
Yeah.
Thank you.
Now is it okay?
Yes, sir. Yes, sir.
Yeah. Was it for the long time?
No, sir. Just 5 seconds.
Yeah. Okay. Thank you. Okay. I think I'm audible now.
Yes, sir.
Yeah, so he was telling about adultery, sir.
Yeah. I'll come to that. Okay. Can I proceed for another 10 minutes?
Yes, sir. Yes, sir.
Sure,
Sure,
sir.
sir.
Yes. I'll just take another 10 minutes before I go to questions, if at all they are there. Okay. By mistake, it was muted. Now, I was studying about the case of Joseph sign, adultery. Section 497, it says that when any person without the consent or connivance of the husband of a woman, if he indulges in sexual intercourse with her, that is an adultery. It means if there is a consent of the husband, it is not an adultery. If there is no consent, it amounts to adultery. Now the prominent questions are, if the third person indulges in sex with one's own wife, and if he's not consenting for it, he can file complaint against that man. And this is also one of the grounds for divorce for that man. That's the end of the story here. But if a man indulges in sexual relationship with another woman, can the woman have the same provision? There is no, under the Indian Penal Code. Is it discriminatory? This is one question. Another question is, if the husband is consenting, it is not an offense. If the husband is not consenting, it is an offense. Then, whether the wife has got no say at all, is the wife's chattel, is the wife a property of the husband, whether she has got her own share on her body or not. This is an important question. So in that way, the question was cropped up in Joseph's time, and the Supreme Court came down heavily against this 497, and it has decriminalized adultery now. Now, when section 497 treats the woman as just a property of husband, this is violative of Article 14, 15, and 21, and human rights. So all importantly, section 497 has been decriminalized. And with this, we are again onto the conclusion that human rights have emerged victorious. Human rights of women have emerged victorious. But one thing has been left untouched. That is, adultery can be still used as a ground for divorce for either party. Okay. In that way, there is this for a Joseph sign case, as I wanted to tell about this case. Then I want to take you to another case that is about this marital rape. In this marital rape case, okay, the case which has settled the law at present is this X versus Principal Secretary, Health and Family Welfare Department of Government of NCT of New Delhi. Marital rape, again, before I go to the last case, this is the one case which I wanted to touch upon. This is about the marital rape. There is one enactment called as the Medical Termination of Pregnancy Act. Under this act, there is provision for abortion up to 20 weeks, not beyond 20 weeks, except under some exceptional situations. But the law has been amended in such a way that if there is the victim of rape and if she is pregnant, she can undergo abortion even beyond that period of 20 weeks or 24 weeks as the case may be. It means a raped woman, if she is pregnant, this MTP restriction of not aborting beyond a certain period is not applicable to her. She can go for abortion provided her health and all permits for that. This is what the law has been amended. Now, in this case, in the case which I referred, a married woman, whether she has got the right to abortion, if her consent was not there for sexual intercourse. So the pregnancy has taken place in a woman and she has become pregnant because of non-consensual sex with her own husband. Can she undergo abortion as of right is the question. The matter came up before the special bench, before the Supreme Court. Again, the court said, yes, she can. When a married woman comes up for abortion and when an unmarried woman who is raped or married but raped comes up for abortion, there should not be a difference, because just because a woman is married, she should not be discriminated to have ownership of her body. Whether she is married or unmarried, she should have the same right of abortion under law, that is MTP law, is the decision of the Supreme Court. But the Supreme Court has not deleted the exception to Section 375 rape. In rape, Section 375, we say that if a man indulges in sexual intercourse with his own wife, the wife being more than of the age of 15 years, it's not a rape at all. That is not undone now. Even now, if a husband indulges in sex with his own wife without consent, that is not a marital rape. I make it very clear. Rather, Supreme Court has made it very clear. Even now, marital rape has not been explicitly provided, criminalized under the Indian law. But marital rape has been the ground for abortion. So this is, again, the human rights perspective of this judgment. The last case which I want to say before I close for question and answer is right to life. It is human right. The paramount human right is the right to life and personal liberty. It is being so recognized under the UDHR, even under the European Charter of Human Rights, under our constitution, like in any country, this right is there, right to life. Now the important question is whether the right to life includes right to die, is the question. This matter came up in Ratinam Patnaik or state of Orissa in the year 1995 or 6. Section 309 of Indian Penal Code, punishment for attempting suicide. This was challenged before the Supreme Court, stating that when we have got the right to live, we have got the right to die also. Accordingly, when we attempt suicide, that should also be not punished. So remove Section 309 from the Indian Penal Code was the request before the Supreme Court. Supreme Court said yes. When you have the right to live, you have got the right to die also. That was the decision of the Supreme Court in Ratinam Patnaik in 1996. Just after 6 to 7 months, another case came up before the Supreme Court. That is Gyan Kaur versus State of Punjab. In that case, the same facts were there. Section 309, the government appealed to the Supreme Court stating that Section 309 should not be ousted from the Indian Penal Code. Attempt to suicide must be still a crime. It should not be decriminalized. Argument of the government before the Supreme Court. It was argued before the Supreme Court that under Article 19, we have got the freedoms. Freedom to speak. I have got the freedom to talk. I have got the freedom to remain silent also. I have got the freedom of movement here and there. I can remain in one place also. I can use my freedom positively or negatively. But rights cannot be used negatively. I got the right to live. I cannot have the right to die. I cannot push it to that extent. So in that way, there is no right to die. So everyone has got the right to dignified death. Attempting suicide and dying is not a dignified death at all, Supreme Court said. Accordingly, Section 309 was restored back to the Indian Penal Code. This is the fate. Now, what happened subsequently? I take you to Aruna Shanbag case now. Aruna Shanbag case, and probably most of you may be knowing. What happened? A staff nurse was brutally injured by a boy there who was working in some hospital. He took a dog chain and strangulated her neck, pulled it in such a way that she went into coma. His object was to rape her, but she was menstruating. So he indulged in sodomy with her and he went away. But that lady went into coma for around 39 years or so. I'm not specific about the years. She remained in coma in the hospital. And for all these years, she was fed by the same hospital. Then one petitioner by name Pinky, I think her name, she petitioned before the court seeking mercy death or mercy killing. The life support system which is given to her because she's in coma. The life support system is there. Some food is put into her mouth and she swallows and she opens her eyes and she closes them. Like that, her life is going on for decades together. And she said, how long we should proceed? When we are sure that she can't be all right, let us remove the life support system and let her meet the happy death. This was the contended before the court by her. But hospital authorities said, we don't have any problem in supporting her. And when we put food, her eyes become little bit brighter. When she is hungry, her eyes become closed. So we are very happy to feed her. So we are not able to remove the life support system. And according to the court, agreed with that. But there, incidentally, the court said that the situation is too worst. There should be some committee by judges, doctors, etc. And they should sit together and they should decide if at all it is worth life support can be detached or withdrawn. That decision can be taken by the judge. So that decision was given, of course. This is called as passive euthanasia. So passive euthanasia is recognized as human right to some extent in Aruna Shanbag case. Then coming to active euthanasia, can it be in common cause case? Subsequently, another petition is filed before the Supreme Court, and the Supreme Court said there, Supreme Court has invented a concept of living will. Now I'm all right. I can write a will. Usually, will can take effect after my death. But here is a special case of will which can take into effect during my lifetime only. That is, when I'm all right now, I can write a will stating that in the event I meet with any disease or illness, if I am admitted into the hospital, and if I am having no possibility of recovery, life support system should not be there to me. Particular extreme treatment should not be there to me. And I should be left alone to die on my own, naturally. So I don't want any such special treatments. I can write a will and I can die now. And I can leave it now. So if at all I go into the coma and all, the will comes into existence. In that way, human rights have been recognized. One thing, what I want to say here is, society is changing. Human rights are also changing. The types of human rights are also changing. The extent of human rights is also changing. Let me tell you, just to conclude, as to how the human rights jurisprudence is enlarging, is we had new human rights, right to development. That's the old concept now. Now we are on to another concept as right to be forgotten. Right to be forgotten. What is this right to be forgotten? Suppose I have made a lot of loan and banks have auctioned my property. And it has come in some bank's website that the property of this and this fellow is being auctioned and all. That page has come. And automatically that is being uploaded in Google also. Now my property is taken and the loan is taken rid of and the loan is closed. Everything is all right. Even after 20 years, if somebody Googles my name, that auction of my property will come. will it not be defaming my name or not? Because after that, I'll be very much okay, and I'm very much happy also with my properties and well-being. But it will be affecting my rights. So there, I can insist that my page in Google must be removed. That's my right. So it is called as right to be forgotten. So if any person's information is shared in public domain, after some time, reasonable time, he has got every right to see that that information is not revealed to the public after some time, even if it is in their custody. And in that direction, we need a data protection law, and that is just in the pipeline now. So I think with these remarks, I just say that human rights are very precious. We should understand human rights. We should practice human rights. We should propagate human rights. So these are the three messages which are supposed to be spread by all of us to one another. And having said about this, human rights and the intricacies of it as regards law and the society, I'm closing here. I am quite open to the questions. Organizers, please.
Thank you very much, sir. Your detailed explanation is really enlightening to us, sir. So now the forum is open for question hour. So there is a question by Mr. Sibesh.
Yes.
Social transformation in human rights occurs through technology in today's time, but can we say it also hinders development as majority people? It also hinders development as majority people take time to get accustomed with technology, and in some way technology slows down social transformation as it's advancing in nature and has its own loopholes as well in terms of hacking and other cyber crimes and frauds, etc.
Yes.
So it is in the chat box.
Yes, it is. And you read it, I understood what the question is. Okay. I can read the questions if they are there in the chat box. I can listen to it and understand. Okay. This question, I referred to it in my lecture that technology and society, there can be interplay between technology and the society. To our needs, we evolve technology. And the technology also can leave so many impacts on the society. And in the process, there will be time for adjustment for both technology and also for the society. This is a period of transition. In this period of transition, there will be a lot of litigations also. And the state or the courts and the law must try to balance between technology and the needs of the society. So there, the courts must perform the healthy role of picking up the good technology, restricting it on legitimate lines, allowing it to happen, because we cannot forego the technology just because it infringes our rights. We should have the technology, and we should also evolve mechanisms to see that the technology is not misused. That's all. We have got so many laws and judgments on that is electronic evidence.
So, can you give just an example, like in a scenario, like how it doesn't also, the technology doesn't differs from the myths and beliefs of the people as well?
You mean to say that the technology differs from the beliefs of the people, or it doesn't differ?
Doesn't challenges in some way.
It challenges the beliefs of people.
Yes, sir.
Yeah, that is happening. The moment you open your mobile phone or social media, what is happening is so many hundreds and thousands of together advertisements are coming, and the wanted steps, unwanted stuff, everything is coming up, and the kids are seeing it. Okay, is it not a challenge to our kids, even to the elderly people? Is it not encouraging the people to commit crimes, sexual offenses?
Them too.
Yeah, these are all the ill effects of the technology. But the question is, people should fly to the higher level of maturity now. Instead of blaming the technology, I should be able to pick what I want. I should be able to ignore what I don't want. So individuals' wisdom is more compact and more responsible now. That's how the technology has made us more responsible people now. If we are nonsense, we are drowned. Nothing can be done. Yeah.
Thank you very much.
Mr. Nagarjun Gowda has raised his hand.
Yes. He can speak. Allow him to speak.
Yes, sir.
Yeah,
good evening.
Yeah, good evening.
Sir, if we talk universally, America has declared a certain basic human rights which contains 30 articles and it is accepted by 48 nations. So,
Yes.
what is the necessity of accepting it when we have all those rights in our constitution?
Yes. Okay. Right. One thing is to be understood here, that these fundamental rights, or the Bill of Rights as we refer, they emanate basically from the US Constitution, because the US Constitution is the oldest constitution. All of us know that. And subsequent developments are this Universal Declaration of Human Rights and the Indian Constitution and European Charter of Human Rights. All these have come later. And the spirit of all our human rights is derived from that American charter as such. That's how that thing happens in the international level. And another factual reason for that is there is a big power and people are trying to respect that nation even unnecessarily. Okay. Even if we are able to develop very good jurisprudence than them in human rights, best we salute them because they are big powers. Sometimes it happens. 40 nations is a very less number for them. They are so powerful.
Thank you, sir.
Yes. Any other question?
Sir,
Yes, sir.
Yes, please.
Yes, Ms. Gopi.
Sir.
Yeah.
sir, as law is instrumental in social transformation, are there any chances that such law can have a negative effect on human rights?
Okay. Your question is, can the social transformation have negative impacts on human rights?
Yes, sir.
Yeah, this is possible, madam, because what is happening now is the parallel legal system, I should say, parallel legal system. Because when laws come, laws are used, but the laws are misused more. Say, for example, this real estate dealing. We have got laws relating to the real estate. What is happening is laws are there, but what the society is doing is, yes, what the society is doing is the dealers and the persons involved in real estate are still able to exploit the farmers in terms of grabbing their lands, still able to exploit the persons who are opting for sites. They are misusing the provisions of law. I say that we say that the sale takes place on the agreement of sale or the sale deed, but the sales take place on power of attorney, general power of attorney. Is it not the misuse of law? Yes, laws can definitely lead to this social transformation at the wrong direction, towards the wrong direction. That is also possible. But the law has to come up again to check it.
Okay,
There is some
sir,
similar
thank you.
question in Ms. In the name of rights, if any law or judgment is passed, and what if such law or judgment has a negative effect on the society or any social transformation as a result of such law or judgment is not of positive manner?
Okay, right. One thing, there is a judgment, it declares a right as a legal right, but it will have adverse effects on the society. This is the question. The same thing has happened as regards this adultery now. People say that now if the wife indulges in the sexual intercourse with the third person, it is no offense at all. This is so declared by the court. That is her human right. Correct.
Yes.
What is the effect on the society? Is it an adverse effect or a good effect? Is the question. A lot many people say that it is having an adverse effect. 100% true, but it all requires some transition. We have to undergo that transition. And we have to come to the conclusion that if a person is having the wife, he has the risk of sharing her life with another person. And there has to be some sort of understanding between them. And institution of marriage is on the different levels now. It is losing its sanctity as it was there some decades back. So the very institution of marriage is changing, whether it is good or bad, but that is happening. But the society is like that, no? The new generation is tasting it. The new generation is liking it. The present generation is not liking it, but the new generation likes it. That's how we see that it is going in the wrong direction. But if we ask the youngsters, they will say that it's good. That is the situation now.
Connected question, sir, by Mr. Shiva.
Yes.
What is the human right for men in social structure of marriage?
What is the human right for man in the
Yes, sir.
institution of marriage? Yeah,
Yes,
he
sir.
has got the similar rights as that of woman, 100%. But the only thing is, the law is bit feminist oriented law. There he has got lesser rights. For example, he can see his wife can claim maintenance against him, whether he works or he do not work. Even if he is not working, if he is physically competent, he has to pay maintenance. What can he seek maintenance against his wife also under the civil law? Yes, if she is earning. If she is not earning, she can't. He can't rather. So there is some disparity, 100%. But man also has rights. He has conjugal rights. As the wife has the rights against him, so also he has the rights. Only thing is, since the society is characterized by the exploitation of women, we see only the enforcement of women's rights. That is we come to the conclusion man has no rights at all. That is our grievance.
Yes. Thank you, sir.
Yes.
Sir, one more question from Ms. Vandini Sharma. Respect, could you please give another example of society can change in defiance to law?
Society can change in defiance to
In
law.
defiance.
Yeah, in defiance to law. Yes. Society can change in defiance to law. So the throwing out the law, society can still change. That has happened because Dowry Prohibition Act. What has happened in Dowry Prohibition Act? There is a law, and the majority families have defied that law, and dowry is still practiced in one or the other way. This is another example. To give you another example, child marriages. When child marriages take place, there is a clear signal from the law that the children should not be given or taken in marriage. But what if they are already given or taken? They can exercise their option of coming out of it after coming to the majority for 1 year. So there may be a lot of pressure exerted on them, and they will be continuing in the marriages. So law can defy the society can defy the law, and it can practice its own ill practices. So child marriages are happening even now. That is another example.
Sir, there is a request from Mr. Shivendra Sinha. As discussed, right to be forgotten is upcoming part of human right. Please make it more
Make it more
clear. Maybe he's expecting some more explanation.
Make it more clear. Okay, make it more clear. Okay, a good question. In fact, I expected this question. I'm happy that I have reached the participants here. This right to be forgotten has not yet been recognized validly or formally in any Indian courts now, so far. It has been recognized in one of the cases. I think that has also not ripe. I do not have the proper information about that, but this is very much prevalent in American society. Right to be forgotten. To give you an example, suppose I was the special officer in a particular section in Government of Karnataka. And when they were developing this website, they took my number, they placed my number there because people come to High Court to speak to government officials regarding their cases. My phone number was listed there. And now I'm no more in that work now. I'm back to my teaching profession for the last 3 years. But still, people Google it, my number comes and they call me. Every day I receive not less than 3 to 4 calls. Now I have written to Google, but still my number and name is not deleted from that. Now, is it causing annoyance to me or not? Yes, it is causing annoyance to me. I can have the right to be forgotten. You just should forget that I was the special officer there. It is my right. In that way, right to be forgotten is an emanating right. It is coming up. And for example, especially in the marital sphere, people are divorcing the spouses, ex-wife. Suppose if person's name is typed, now his ex-wife's names will come. That he may not be willing to have. This should be removed, no? So in that way, there will definitely be the recognition of that right in a widespread in this country also in the days to come. That's what I think. Yes.
There is a question from
Thank you,
Ms.
sir.
Rinshi Shivam. Sir, can you suggest any steps to prevent the disadvantages of passive euthanasia as human right?
Passive euthanasia, okay, disadvantages. It is disadvantages only that, so it is not permitted until Aruna Shanbag case in this country. What happens is, in the name of passive euthanasia, the relatives, without bearing the financial expenses of the treatment, they may deliberately going for the withdrawal of life support system. And this will lead to, in terms of the murder only, no? So in that way, it is very much possible that the people may indulge in this deliberate causing of deaths. Because for man, money is everything. When there are no prospects of recovery, people don't want to spend money. So this is possible, quite possible.
Any more questions or anything to discuss with sir? So, sir, there are no questions as such, no?
Yes, thank you. Thank you. You can wind up.
Sir, I request Mr. Sivesh Patnaik, LLM first year student, to propose vote of thanks.
Krishna, 1 minute, Krishna.
Yes.
Sir, yes, sir, Dr. Basura, sir.
Really, I'm very happy today because my teacher took this class for me, and I remember when I was studying at LLM, it was wonderful, sir. You have enlightened us, and we're very grateful, thankful for your wonderful lecture, sir.
Okay, thank you, sir. Thank you.
So
Because of the guidance and mentorship, I did come to this step, and he is my mentor.
Yes. Thank you for your nice words. And in fact, I am profusely thankful to all the students here. And next, I thank the students because you are all the students of my student. Because he is my student, you are his students. Okay. It is a unique opportunity for me to interact with you people. And all the best to you. I really thank you for this opportunity.
Really, sir, very enlightening session and wonderful session. Sir. Thank you.
Thank you.
Thank you very much, sir. So with the permission of Dr. Basura, sir, I proceed to Mr. Sibesh.
You offering vote of thanks?
Yes, sir.
Yes, please.
Ragini ma'am has a question, sir, again. I think.
Yes.
Sir, there is a question. Sorry.
Yeah, please.
Sir, marital rape, do we need any separate legislation or IPC provisions of cruelty sufficient for the punishment? If yes, how will the parliament make sure it is again not skewed towards female gender?
Okay, marital rape, if it is to be taken as law, Indian Penal Code should be amended. One thing. And if there is no need to have any special legislation, Indian Penal Code needs to be amended. And even now, there is need to amend Medical Termination of Pregnancy Act also, because that act has so far, only by way of judicial judgment, this marital rape, that is abortion for the wife, it is being covered by virtue of judgment. So this should be legitimized by way of legislative amendment to MTP Act. And if at all marital rape, now so far marital rape is not, it is not criminalized now. I said it can be used only for the purpose of getting divorce. Okay, that is adultery and all that. But
yes,
it's not the thing here. So to have it as an offense, IPC should be amended.
So there is one more question. What is passive euthanasia of human rights?
What is passive euthanasia?
Of human rights.
Of human rights. Okay. Passive euthanasia is a form of human right. When a person is very much alive, he can exercise his human right of saying that if I fall ill and if there are no chances of recovery, the life support system put to me be withdrawn. I want to end up life like that before undergoing years together treatment. I don't want that. That kind of wish one person can express, that is called as passive euthanasia. In passive euthanasia, what happens is we don't kill him, we have placed him on life support system. We just withdraw the support and he dies on his own. Passive euthanasia.
We
Active
can say
euthanasia
it as
means
a form
we
as
have
an
injected.
assisted suicide.
Yes, assisted. Yes, it is
Assisted
against
suicide.
assisted euthanasia. You are right.
Thank you, sir.
Yes, thank you.
Mr. Sibesh.
Yes, thank you, sir. Good evening, everyone. I, Sivesh Patnaik, first year student of LLM, consider this occasion as an honor and privilege to have been asked to propose the vote of thanks. Once a great man whispered, feeling thankfulness and not expressing it is like wrapping a present and not giving it. On behalf of Department of Law, Central University of Karnataka, I thank our resource person, Dr.M.K. Matolli, sir, from the core of my heart for illuminating us all through your detailed lecture. Sir, your speech on human rights, state compliance, and social transformation has indeed inspired us all at the present. As you rightly said, sir, law is an instrument of social change, and state is not to dictate and punish people, but promote welfare of people in a noble way. Also, you gave us all a deep understanding of human rights, that is, the rights available to all humans, which are indefinite in time, universal in application, and individual in recognition. Thank you, sir, for explaining while deliberating the positive and negative aspects of human rights compliance by state with respect to Article 21 of Indian Constitution. Also, sir, thank you for explaining the concept of social transformation in terms of human rights. As you rightly said, human rights are not only an effective way to bring about social transformation, but they are also an indicator of states' governmental administration and democratic governance, such that they also constitute as an indicator of social transformation. Thank you, sir, for elaborating, exemplifying, and giving us idea how factors such as technology, demography, human population, legal system or law, public opinion or mass movements, etc., impact social transformation of human rights, and also giving us vast information through various case laws, as you mentioned, regarding adultery, child marriage, marital rape, etc. Once again, thank you, sir, for influencing us with your words of wisdom. I would also like this opportunity to thank Basavaraj, sir, Associate Professor HOD in Department of Law, and Anand sir, Assistant Professor and IQAC Coordinator, Department of Law, for taking an initiative and organizing this wonderful lecture series, Events on Human Rights. I would also like to thank Krishna sir and Rakini ma'am for making sure this online mode of lecture series was made available to all interested participants and helping them join the same. Lastly, I would like to thank all the students, teachers, research scholars for being a part of this wonderful interactive and informative session. Once again, thank you one and all for making today's lecture fruitful and educational. Thank you.
Thank you.
Thank you, sir.